Okay, welcome. Greetings, everybody. And welcome to the 2021 Paul J. Schrag Lecture in German Jewish History. My name is Tony Michaels. I'm the director of UW Center for Jewish Studies and a professor in the Department of History. And it's my pleasure and honor to introduce this year's Schrag Lecture. The Schrag series was established with the generous support of Fran and Sally Schrag more than 2 decades ago, and has brought distinguished scholars working in the area of German history to UW under the joint auspices of the History Department and the Center for Jewish Studies. This year is unique because not only are Fran and Sally in attendance virtually, but so are all 3 sons of the late Paul Schrag, 1 granddaughter, and possibly another, I understand. So I want to extend a special welcome to the extended Schrag family. I'm glad you could be here. A few words about this afternoon's esteemed speaker, who I'm very pleased to introduce. James Q. Whitman is the Ford Foundation Professor of Comparative and Foreign Law at Yale Law School. He earned his BA and JD from Yale University and Law School, and also holds an MA in European History from Columbia University and a PhD in Intellectual History from the University of Chicago. From 1988 to 89, Professor Whitman clerked for the Honorable Ralph K. Winter of the Second Circuit Court of Appeals, then began his teaching career at Stanford University Law School before moving to Yale in 1994. Professor Whitman is the author of many articles and books published across disciplines. His 2003 book, Harsh Justice, Criminal Punishment and the Widening Divide Between America and Europe, won the 2004 Distinguished Book Award of the Division of International Criminology of the American Society for Criminology. In 2008, he published The Origins of Reasonable Doubt, Theological Roots of the Criminal Trial, which received the Silver Gavel Award honorable mention from the American Bar Association. His book, The Verdict of Battle, The Law of Victory and the Making of Modern War, appeared in 2012. And more recently, Professor Whitman has published Hitler's American Model, the United States and the Making of Nazi Race Law, which is the basis of this afternoon's lecture. Ladies and gentlemen, please join me in virtually welcoming Professor Whitman to the University of Wisconsin.
Well, Tony, thank you very much for the virtual welcome. It's really a thrill to be here, and I'm awfully glad to hear that I'm in the presence of so many Schrag family members. So it is a pleasure to, I guess you'd say, beam in to a great university, and in particular to give a lecture that honors, at least in part, George Maussa, whose name I know appears on the title of the center. If you'll allow me to just reminisce for a moment. Please. The first professorship I was ever offered was in the Madison History Department, where I would have been Maussa's successor, a fact about which I remain quite proud. I had to turn the job down for the most familiar and most dreary reason in modern academic life. There was no job in Wisconsin for my wife. And the 2 of us ended up as law professors instead, which is not a sad fate, I guess. Still, I remember conversing with Maussa, who seemed puzzled and saddened by the notion that anyone would give up the profound calling of intellectual history for anything as limited and banal as the law. And I will say, I have certainly experienced moments of doubt in the early morning hours when I wondered whether he was right. He was, after all, a great historian and a great mensch. And he was certainly right in believing that the law only touches on a narrow slice of human life. For better or for worse, though, I ended up as a law professor, and today I'm going to speak both as a law professor and as a historian. The topic that I've announced is assessing American responsibility. Assessing responsibility is, of course, the main task of the law, and in particular, the criminal law. But historians must assess responsibility too, especially when it comes to a sequence of events as horrific as the crimes of the Nazis. The assessment of responsibility is indeed one of the most pressing duties that historians of Nazism face. Who precisely can be saddled with what share of the blame? My purpose this afternoon is to address this question both from the point of view of the law professor, and in particular the professor of criminal law, which is a subject I teach, and also from the point of view of the historian. I'm going to try to convince you that some concepts of the criminal law may be useful in informing our thinking. In the end, though, the criminal law answers are unsatisfactory. Only historians can properly assess historical responsibility. That will be my conclusion. So the problem for today, is there any sense in which America can be saddled with blame for the crimes of the Nazis? Is there anything in particular that criminal law can tell us as we try to weigh that question? Let me begin by summarizing the facts that might suggest that America deserves blame. As my book, Hitler's American Model, aims to show, there is a shocking history of American influence on Nazi race law. Nazism emerged at the height of the Jim Crow era in the United States. And in the early 1930s, Nazi lawyers were fascinated by and even inspired by some of the ugliest of Jim Crow era practices and teachings, which they studied carefully. It is a particularly disturbing fact that the most radical Nazis, such as the infamous Roland Freisler, the president of the notorious Nazi People's Court and a man of bottomless savagery, were especially eager consumers of the fruits of American legal racism. Some of what attracted these monstrous figures involved American eugenics and eugenic legislation, whose appeal in Nazi Germany has long been well known. But eugenics was only a part of the story. Nazi lawyers were drawn to the whole array of inventive legal techniques that Americans had crafted in order to create a culture of degradation and disenfranchisement. American race law was not just about eugenics, not just about population engineering. It was also dedicated to the creation and enforcement of a social system of racial hierarchy, a system of what Isabel Wilkerson in her best-selling recent book calls caste. Many of the techniques that American lawyers developed targeted African Americans, of course, especially in the South, but not all. Asians and Native Americans were singled out as well. Amy, if I could cue the map at this point for a couple minutes. I call your attention to the Nazi map of the United States, reproduced in the poster for this lecture, which charts the racist law of the period in all 48 states as they existed in 1936. Nazis were interested in the law of every one of those states. For a radical Nazi like Freisler, much of what was most exciting about American law involved techniques for dealing with a challenging legal problem. Who counted as a member of a disfavored race? Were persons of mixed ancestry to be counted as Black or Asian? America produced a rich body of answers. The most notorious example is the one-drop rule, by which persons with even one drop of Black blood were classified in parts of the United States as Black. Nazis needed rules like that too. Yet it is striking to note that Nazis, even the worst of them, sometimes found the law of the Jim Crow era too radical for their tastes. I think the map can go now. They were, for example, unwilling to go as far as the one-drop rule. They also made a point of insisting that Jim Crow segregation went too far in some respects. In these regards, Americans, and this is one of the most disturbing findings of my research, were too racist even for Nazis. What was it that made the United States an attractive model for this criminal regime? In my book, I give two answers. The first has to do with the sheer innovativeness of American legal culture. Racism was, of course, to be found throughout the globe, in that the United States was hardly alone. But Americans, then as now, were unusually inventive, unusually ready to break with the established traditions of the law. American lawyers are creative. And when it came to race law, they devised innovative forms of legislation and empowered popularly elected judges to enforce racist policies. To that extent, American race law seemed appealing to Nazis in the 1930s for the same reason that American contract law or American corporate law seems appealing to entrepreneurs and market reformers around the world today. America is the land of creativity, and people around the world admire us for that, including racists. There is also a second answer to the question of what made America attractive to the Nazi movement as well, a very important geopolitical answer. After the First World War, the United States had emerged as a or the premier power on the globe, Hitler, too, wished to make Germany a or the premier power on the globe. America thus offered itself not just as a model of legal innovation, but as a model of global power. Moreover, from the Nazi point of view, it seemed self-evident that the secret to American geopolitical success lay in its highly developed racist policies. If the United States had ascended to the pinnacle of world power, it had to be because the United States was racist. The Nazi literature tended to view the United States as a triumphant white supremacist order, and one whose triumphs were the reward for its commitment to white supremacy, though many Nazis and other far-right wingers in Europe speculated that the US would eventually fall because its commitment to white supremacy was insufficiently rigorous and ruthless. This understanding of the role of the leading role of the United States as a white supremacist power in global affairs plays a fundamental part in the story told in my book, which is about the American influence on the making of the Nuremberg laws in the early 1930s. It also plays a leading role in another aspect of American influence, which has been traced by scholars other than myself in their murderous expansion eastward. Hitler and other Nazis cited the example of American expansion westward. For these Nazis, the US served as the shining example of an imperialist power claiming new lands, Lebensraum, through a program of the extermination of an indigenous population. All of this adds up to a profoundly distressing story, one that is not pleasant for any American to tell or read. I should emphasize that the views of the US that I have just described were not the only views to be found in Nazi Germany. Nazi commentators were also aware that there was a competing liberal tradition in the United States, which they regarded with contempt. They always understood that there was more than one America. Nevertheless, the story of American influence is one that ought to shake all of us, not least since it has become so clear in recent years that white supremacy has by no means vanished from the national scene. But does this distressing story warrant the inference that the United States was in any way to blame for the crimes of the Nazis? That is the question I want to talk about today. In my book, I want to begin by confessing I made a studious effort to avoid answering that question. I'd like to explain why I tried to avoid it in the book before launching into my effort to answer it this afternoon. As I drafted my book, I was at great pains not to say that the crimes of Nazism were caused, if I can put that in quotation marks, caused by the American influence that I traced. I had two reasons for avoiding the language of causation, both of which matter for the argument that I am going to offer today. The first reason was pragmatic. It had to do with the possibly inflammatory implications of my research, especially in Germany. I was aware that my book would have German readers, and I wanted to avoid triggering what might have been some angry German responses. Anybody familiar with German intellectual life of the past few decades will know what I have in mind. Germans, at least decent-minded Germans, are rightly resistant to any argument that might tend to relativize the claims of the Nazis. That makes it extremely uncomfortable to talk about any sorts of parallels to what the Nazis did. Let me emphasize that Germans are entirely justified in such sentiments and that they deserve our admiration for their refusal to water down German guilt. Efforts to downplay the horrors of the period have, after all, often taken the form of arguments that the crimes of the Nazis were nothing exceptional, that they just did what others did. The Nazis themselves traded in such arguments. Somebody outside Germany was always to blame. But in the post-war world, the most notorious argument of the kind was mounted, as many of you will know, in the course of the historical Streit, the historians' war of the 1980s, which broke out because one historian, Ernst Nolte, pointed the finger at the Soviet Union. Nolte's allegation, in part, was that the crimes of the Nazis were paralleled by the crimes of the Soviets, but he also made the outrageous suggestion that it was justifiable fear of the Soviets that had driven the Nazis to act. The Soviets in that sense counted for him as the provoking cause of Nazi crimes. Now, in my book, I wanted to be excruciatingly careful not to align myself with Ernst Nolte or anybody like him. God forbid. My aim, unlike Nolte's, was not in the least to deflect responsibility from Hitler and the Nazi movement. I stated the contrary as forcefully as I could. And to that end, I emphasized that I was not arguing that American influence had caused the Nazis to engage in their crimes. I also tried to make it clear that my intended audience was not Nolte's. My book is addressed to American readers, not German ones. Its purpose is to force Americans to reflect on America and America's place in the world. Nevertheless, I knew that I had to brace myself for attacks from Germans who might accuse me of relativizing the crimes of the Nazis. In the event, I am glad to say there were very few such attacks. Most of my German readers read the book in the spirit in which it was intended to be read. Alongside my pragmatic reason for avoiding saying that American influence caused the crimes of the Nazis, I also had a reason growing out of the philosophy and methodology of history. And this second reason matters very much for my subject today. I hope it's all right if I talk a little bit about philosophy and methodology of history. As thoughtful historians understand, it is always dangerous to speak of human events as having been caused. This has to do with methodological grounds most familiarly stated by Max Weber and ultimately founded in the philosophy of Immanuel Kant. Human beings have free will, which implies that they are not subject to causal forces. The actions of billiard balls are mechanically caused. The actions of human beings are never caused. Take the example of the monster Roland Freisler. He was not caused to become a Nazi or to embrace the American model. In the way that a billiard ball is caused to move when struck, he chose to become a Nazi. And he chose to look to America. The same applies to Nazism more broadly. Nazism was the product of innumerable human choices and chance events. It did not happen as a matter of necessity. It might all have turned out differently. To the extent we only blame people for the acts they have caused, no American or anyone else could be blamed for what Freisler did. He alone was responsible. More broadly, every individual participant in the crimes of the Nazis was the person responsible for his or her choice. In that sense, no study of American influence could ever have any ultimate bearing on whether the Germans were to blame. That implies that, at least at first glance, America could not be said to bear any share of the blame for the crimes of the Nazis. Yet that conclusion surely seems unsatisfying. Is there really no way of ascribing blame to America, given the story I've just told you? Today, I want to go beyond what I argued in my book, beyond the language of causation, in order to suggest that there are sensible ways of talking about America's blameworthiness, sensible ways to be found in the teachings of criminal law, but sensible ways that have to be extended and modified in talking about history. Let me preface what I am going to say with a protestation in the hope of fending off what might be the appropriate objections of any decent-minded Germans who may have tuned in. To speak of American blame is, let me say again, not in the least to deny German blame. Of course, American influence does not excuse the crimes of the Nazis, any more than the imaginary provocations of the Soviets do. Nevertheless, American influence is a fact, and it is a fact that raises questions about the genesis of Nazism that deserve a serious hearing. Given that we know that the Nazis were in some measure inspired by the American example, is there any way in which we can appropriately speak of American responsibility, even as we remain careful not to call American influence the cause or American parallels the excuse? That is the question I would now like to tackle. I am going to ask you to follow me through some technical, legal, and philosophical arguments. There are several possible approaches to thinking about American responsibility that I will discuss. Not all of them are persuasive, and I'm going to take us down some argumentative blind alleys. Nevertheless, there are blind alleys that it is worth going down. Even weighing and discarding answers can be a helpful intellectual enterprise. My ultimate conclusion should, I think, seem unsurprising. Legal concepts of responsibility, notably concepts of responsibility developed by the criminal law, are stimulating and thought-provoking and well worth discussing, but they cannot do the job. You could not put America on trial for the crimes of the Nazis, or at least you certainly could not get a conviction. In the end, we have to develop non-legal concepts of historical responsibility, but it is valuable to do so. Developing appropriate concepts of historical responsibility, I will end by suggesting, may help us think about in valuable ways about the challenge raised by Nolte's notorious efforts to relativize American crimes. In particular, I'd like to discuss three possible ways of assessing American responsibility, which I will call pollution, complicity, and geopolitical responsibility. I begin with pollution. There is one widespread, intuitively appealing, but manifestly wrong way of responding to the history of links between the US and the Nazis. And that is what I want to, and it is one that I would like to begin by rejecting outright. That is the response that sounds in the logic of pollution. What is the logic of pollution? Pollution language has been much studied by anthropologists, among whom Mary Douglas is the premier figure, and even by neuroscientists who believe they can identify the area of the brain at work in pollution reactions. Pollution reactions involve disgust at contact with what is perceived to be filthy or evil. This sort of pollution response is ubiquitous in the inner life of human beings. It is, I very much hope we can all agree, sub-rational. American law professors these days often draw on anthropology and even neuroscience, and I would now like to do that. I mentioned the pollution response because, sub-rational though it is, it arises naturally, perhaps even spontaneously, whenever we learn of any actor's involvement with the Nazis. We tend to recoil in horror when we are exposed to Nazis or Nazism. Neuroscientists might tell us that our anterior cingulate is stimulated. In particular, we may recoil in horror when we learn of the contact between American law and Nazi law. Certainly, I have encountered such responses when I have presented my research. Radio interviewers and whatnot conclude that I have proven that American history carries an indelible stain of Nazism. The thought runs something like this: we can show that the Nazis learned from the American model, therefore America is tainted by contact with the crimes of the Nazis. Yet I would plead with you all to recognize that the therefore does not follow. This form of response is a non sequitur. Assessment of moral responsibility requires more difficult and subtle reasoning, sounding not in the logic of pollution, but in the logic of guilt. Of course, we are disgusted and horrified by Nazis, but we must work more carefully through the analysis of acts and intents, through the analysis of what the criminal law calls actus reus and mens rea. Unreasoning horror is not the right response, and it must be ruled out. Why then do I even mention pollution? Because I think it is essential that we acknowledge and be wary of the power and insidiousness of pollution thinking, which easily bubbles up from the depths of the minds of every one of us, even the most thoughtful, especially where Nazis are concerned. There is a seemingly unconquerable tendency to believe that anything with a Nazi association is ipso facto foul and horrific. Well-grounded moral judgments are more difficult than that. Criminal law is in the business of forming more well-grounded judgments. Indeed, it is worth observing that Western criminal law formed historically out of the transition from pollution logic to guilt logic. The criminal law that has emerged over the last millennium has produced a magnificent storehouse of sophisticated tools for the assessment of responsibility. Among them is the one that I want to turn to next, the doctrine of complicity. The doctrine of complicity in criminal law is of particular value because it is designed to finesse the same philosophical problem that I mentioned a few minutes ago, the problem of causation in human affairs. I hope that you will follow me for a moment as I give a brief lesson in criminal law. Philosophers of history, as we saw, deny that human events are caused because they insist that humans exercise free will. The only true form of responsibility is individual responsibility for individual choices. The criminal law starts from the same postulate of free will. It too holds that no person can cause the acts of another person. To take an inescapable example from current affairs, it would be impossible to argue that a speech given by Donald Trump caused a mob to sack the Capitol. Every individual member of that mob made a free choice to act. They were not billiard balls put mechanically into motion. Yet the criminal law is not willing to stop there. Sometimes it seems appropriate and even imperative to blame some people for the acts of others. Sometimes there are people who must be condemned in light of something that happened with their encouragement, even if those persons had no direct hand in what happened. To take another closely related example from contemporary American life, we may feel that it is right to blame people who promote white supremacist ideas for violence done in the name of white supremacism, even though they themselves did not engage in those acts of violence, even though those acts of violence were the products of free choices by other persons. Their speech, be it online or at a rally, provided encouragement, or they distributed the weapons, or provided the training or planning. Blame ought to attach to them. The criminal law deals with this challenge through the doctrine of complicity. Complicity distinguishes between two kinds of actors, principals and accomplices. The principal makes the choice to commit the crime and carries the primary responsibility for it. The accomplice aids or abets the principal, notably by providing encouragement or means. The doctrine of complicity holds that if the accomplice provided such encouragement or means, and did so with criminal intent, with the purpose, or in very few circumstances, even the mere knowledge that the principal would commit the crime, then that accomplice, at least in the common law version of the doctrine, is equally to blame for the crime committed. The doctrine of complicity, let me emphasize, is thus designed to solve the philosophical methodological problem with which I started. It radically loosens the link between causation and responsibility. I also want to emphasize just how radical and how sophisticated a departure this represents from everyday concepts of blame. In ordinary lay patterns of justification, we are often inclined to say, I did not do it, and therefore I am not to blame. The criminal law casts a much wider net of blame than that. The interest of this doctrine for the problem at hand should be obvious. I began by repeating what I said in my book, namely that American influence cannot be said to have caused the crimes of the Nazis. In the book, I allowed the implication to go unchallenged that therefore America could not be blamed for those crimes. That form of reasoning comes naturally in everyday life, and I think it comes naturally in the writing of history as well. We are all easily drawn into debates about what might explain causally why Nazism succeeded when it did, for as long as it did, and in the way it did. We are all easily drawn to the conclusion that where there is no causation, there can be no blame. Yet the lesson of centuries of reflection in the criminal law is that the question of blame is independent of the question of causation. Now, it is important to emphasize that the criminal law puts serious limits on the application of this doctrine, which does indeed sweep very widely, and that those limits surely exclude any direct application of the criminal law doctrine to the case of American influence on Nazi race law. The limits have to do with the requisite mens rea. The accomplice must have the purpose, or possibly in limited circumstances, merely the knowledge that the principal will commit the crime. Under one leading common law formula, the accomplice must associate himself with the venture. That standard may suffice, let me say, to convict Donald Trump, leaving aside any First Amendment issues. But if we were to apply the doctrine of complicity in a criminal prosecution aimed at the American influence on the Nazis, the answer is different. We would have to demonstrate that American actors had the purpose, or at least the knowledge, that those crimes would be committed, and we would almost certainly fail. In some sense, we can say that the American example provided encouragement, and in some sense, American legal techniques provided some of the means. Perhaps in some sense, we could say that some Americans associated themselves with the venture of white supremacy that was also the venture of the Nazis. Yet proving American mens rea would be at least as difficult as proving American causation. But to say that the concept of complicity is of no value for our assessment of criminal law, American criminal responsibility, is not to say that it is of no value for our assessment of American historical responsibility. Americans could not be convicted in a court of law for complicity in the crimes of the Nazis on the basis of the influence that I began by describing. And in that sense, they cannot be charged with complicity. But it is important to state very clearly why. Americans could not be convicted because the criminal law deliberately puts obstacles in the way of conviction through the creation of a demanding law of mens rea. We want to make it hard to convict persons of crimes. Yet no one is suggesting putting America behind bars. The question before us today is different. It is the question of whether there is a conception of moral blame that sweeps in the case of American influence on the Nazis, and there is something to be gained from the teachings of the criminal law. Causation is not a necessary predicate of blame. No, Americans did not cause the crimes of the Nazis, and no, Americans did not demonstrably have the purpose or perhaps even the knowledge that those crimes would be committed. Nevertheless, encouraging white supremacist attitudes, pioneering techniques of white supremacist legislation, and in the broadest sense, providing a model of a white supremacist order might reasonably be deemed blameworthy, in some non-criminal sense, complicit, in light of the acts that were subsequently committed by the Nazis. I do not think that should count as a surprising argument, but I do think that working through the criminal law reasoning helps us arrive at it. I further think that it can help us to arrive at what I believe is the better doctrine for assessing American responsibility. This is what I will call geopolitical responsibility. The best way to think about American responsibility, in my view, is not to analogize the United States to a white supremacist disseminating lies and screeds through social media or rallies. It is to hold America to a distinctive standard as a global leader. Let me lay out carefully why such geopolitical responsibility is different from ordinary criminal responsibility. Here again, I hope you will follow me in a brief lesson in criminal law. Criminal law lays down a single standard of conduct for all persons in all walks of life. And for that reason, it speaks in purely formalistic, abstract terms. It judges the acts of the accomplice and the principal without specifying in any particular way their social roles or their social circumstances. But it would be inapposite to speak of the United States and Germany in such formalistic terms as accomplice and principal. Their relationship was lodged in a much more particularized set of historical circumstances. The US of the interwar period was not just any random country. It was a prestigious and powerful polity. One looked to around the globe for its cultural example. At a minimum, it exercised a global cultural fascination, as it still does. Germany, for its part, was a revanchist power, emerging from defeat and hunting for explanations and models. It was in those very particular geopolitical circumstances that the Nazis found a measure of encouragement and technical know-how in the race law and expansionist history of the United States. Although it would be wrong to ascribe to the US the mens rea of purpose or knowledge in connection with the Nazi horrors that followed, it would not be wrong to ascribe to it the responsibilities of global leadership. At least since the time of Teddy Roosevelt, Americans have been proud to lead by example, and leading by example carries responsibility. When we serve as a model, we must answer for what is done. This sort of leadership liability represents quite a distinct variety of complicity, of course, but it does represent a variety of complicity. And for that reason, the question of causation has no role to play in the assignment of blame. If we think in terms of such geopolitical responsibility, as I believe we should, our assessment of American responsibility can speak to some of the most important American convictions about the place of our country in the world. The right question about the American influence on the Nazis is an entirely familiar one. It is the question of whether we have fulfilled our calling to represent the shining city on the hill. Answering that question means acknowledging that the way we conduct our affairs at home will resonate elsewhere on the planet, whether we intend it or not. It is foreseeable, for example, that the events of the last 4 years in our country will have ramifications in countries around the globe. for years. Even if we succeed in putting the crisis of American democracy that followed the election of 2016 behind us, we will continue to bear a collective responsibility for what it has inspired and will inspire elsewhere. In that sense, the American responsibility that burdens us now is not different from the American responsibility of the early 1930s. Let me now turn then to how we should think, a little more detail about how we should think about American geopolitical responsibility. You might think I could stop the lecture here, having offered something of an answer. I do not think that this is so. Real difficulties remain. But let me summarize the argument so far. I have suggested that the United States can be assigned blame for what took place in Nazi Germany under the logic of complicity, even if that blame is only the derivative form of blame that is triggered by geopolitical leadership. Instead of serving as a shining city on the hill, we served as an example of darkness. That argument does not imply that the United States has anything like direct criminal liability for what happened in the camps in the 1940s, or what happened on the streets of German cities and towns in the 1930s. Nevertheless, we should be horrified at what we inspired, and any decent person should feel a sense not just of responsibility, but of shame. We should feel complicit. But it is in the nature of complicity that the guilt of the accomplice takes nothing away from the guilt of the principal. The Nazis may have pointed to the American example. A Freisler may have explained his actions in the 1930s by saying, as many Nazis said at the time, we are only doing what the United States did before us. We did not invent Jim Crow. The Americans did. We are not even carrying the policies of Jim Crow out with the full measure of American ruthlessness. A Hitler or a Hans Frank might say in the 1940s, we are exterminating the indigenous population to our east. But did not the United States do the same thing in its west a half century earlier, if less efficiently? They could say those things, and they did. But the law of complicity reminds us that saying them is no answer to the charge. Yes, the United States served as an example, but you made a free, uncaused choice to do what you did, and you are fully to blame for it. The acts of the accomplice never excuse the acts of the principal. So far, so good. We can blame the Americans without excusing the Nazis. But a deep worry remains. Have I really avoided relativizing the claims of the Nazis in making this argument? Have I said anything that might rightly anger my German friends? Am I following in any way in the footsteps of Ernst Nolte? Does my argument suggest anything about the genesis of Nazism that might raise doubts about whether Germans and Germans alone, along with their direct collaborators, must shoulder the blame for what happened? I hope not. I don't think so, but I am not entirely sure. And I want to run through my closing concerns in the closing of this lecture. Here's what I have in mind. The story of American influence lodges the history of Nazism in a larger geopolitical context. And that context, and I am by no means the only one to say this, is the larger context that is very much on the minds of historians today. It is the context of European colonialism, imperialism, and expansion. The American example appealed to the Nazis because the Americans were the leading practitioners of a style of imperialist, or if you prefer, quasi-imperialist expansion to contiguous continental areas in a way profoundly shaped by ideas of racial hierarchy. Let me note that Americans were not the only such example. There were others, especially in the Anglophone world. Here I will take the liberty of quoting from my book. The backdrop to Nazism is to be sought partly in British traditions. It is to be sought among the English-speaking democracies of free white men, not only in America, but also in Australia, in South Africa, and to a lesser extent elsewhere on the British globe. These were all places where yeoman settlers claimed rights of egalitarian government at the expense of disfavored and sometimes warred upon minorities, and the Nazis looked with interest upon all of them. The Nazis could believe that they were just doing what free white men, especially English-speaking ones, had done before them. And the hard truth, hard for Americans and Germans both, is that they were not entirely off base. Seen against the background of broader world history from the 16th through the early 20th centuries, Nazism looks like the last gasp of global European expansionism. Much of that expansion, moreover, had taken on a racist coloration long before the Nazis came on the scene. The Nazi effort at race-based conquest failed, just as the parallel Japanese effort failed, but those failures were simply the last chapters in a history that had already lasted several centuries. What the story of American geopolitical responsibility inescapably suggests, in short, is that the context of Nazism lies in centuries of European imperialism. Now, let me rush to say that this global historical account of Nazism is not by any means sufficient to explain it in full. The murder of the European Jewry in particular cannot be comprehended to the extent it is possible to comprehend it at all without plunging into the history of the hatred of Jews that extended back 2 millennia. There are plenty of other aspects of Nazism that had nothing to do with the Nazi program of conquest. Nazism was not just an imperialist project. What I have just described is only a part of the story, but it is the part of the story without which the history of American influence makes no sense. It is also a part of the story that complicates the problem of the genesis of Nazism, I think, in ways that complicate the business of the assignment of blame. And I would like to close by mulling those complications. The challenge is one that was most famously stated by Judge Radapinod Pal at the Tokyo War Crimes Tribunal. In his justly famous dissent, Judge Pal asked, what gave the aggressive nations of the imperialistic era the right to sit in judgment on the Japanese? The Japanese were simply latecomers to an enterprise of conquest that the Allies, first and foremost among them the British, had been mounting for generations. The crime with which the Japanese were charged had to be the crime of failing, not the crime of trying, because their judges had tried before them. Judge Paul was something of a voice in the wilderness in the immediate post-war years, but of course, the view of European imperialism that historians have embraced over the last generation or so has come to resemble his. I do not wish to align myself with the most extreme version of that view, especially as it might apply to the Nazis. The Nazis were certainly not just like the British, and they were certainly not just like the Americans. To say anything of the kind would represent a disastrous moral failure to acknowledge the magnitude and horror of Nazi crimes. But Judge Paul's dissent does have to be read as an assertion, does not have to be read as the assertion that there was nothing to distinguish the Axis from the Allies. He was making a subtler charge. His charge was that the aggressive nations of the imperialistic era, by virtue of their own acts, had forfeited the right to sit in judgment on others. That is not an easy charge to answer. Yes, of course, the Nazis were to blame for their crimes, regardless of American influence. But given American acts in the course of its expansion, are Americans entitled to sit in judgment? I find this an authentically difficult question. It really makes me uncomfortable, I have to say. And it is here that I do not know whether I can avoid stirring up anger among my German friends. Decent Germans refuse to entertain the discussion of parallels to Nazi crimes for reasons that are profoundly right. They rule out the invocation of the acts of other nations. Yet in the end, I cannot tell my tale without regarding the Nazi epoch as the last chapter, an unprecedentedly vicious and awful chapter, to be sure, but the last chapter in the history of European expansionism, in which there is plenty of blame to go around. Can I assuage their anger by repeating that the Nazi chapter was unprecedentedly vicious and awful? I don't know. So I end by failing to solve the problem that I avoided in my book. At any rate, let me sum up the argument that I have offered before taking your questions or perhaps fielding your objections. The Nazis looked to America, the Jim Crow era, and more broadly to the history of American expansion for inspiration. This is a fact that can be amply documented, notably through the legal history of the early 1930s, and it ought to make all of us a little queasy. It inevitably raises the question of how we should think about American responsibility in connection with the worst crimes of the 20th century. It would be wrong and indeed incoherent to argue that America was directly causally to blame for those crimes. Nevertheless, we can assign America responsibility for a certain attenuated kind of complicity. This is not criminal complicity in the technical sense. It is the complicity that attaches to the conduct of a geopolitical leader, for the Nazis looked to America as a kind of geopolitical leader in the institutional realization of white supremacy and in the creation of the technical legal foundations for a race-based order. The larger geopolitical context of America's leadership must be sought in the history of European expansionism throughout the globe. Much of that expansionism, not only in America but elsewhere, had been founded in ideas of racial supremacy long before the emergence of Nazism in Germany. It is impossible to make sense of the history of American influence unless we see it in that larger global context. Yet seeing Nazism in that larger global context raises extremely uncomfortable questions, since it highlights what may seem to be precedents and parallels for some, though hardly all, of the Nazi program. I do not know how to answer those uncomfortable questions. And with that, I would be happy to hear any questions you may have.
Professor Whitman, thank you for a very, very thought-provoking lecture. I invite everyone in the audience, anyone who wants to pose a question, please do so through the chat function, and then I will read them and pose them to Professor Whitman. And they're already starting to come in. So I'll start with this one. And it might take a little bit of paraphrasing. Okay. Professor Whitman, do you see any parallels between this question, the American model for Nazism, and the question of whether the Armenian genocide by Ottomans acted as a model for Nazi atrocities? In what ways may the American model and the Ottoman model be parallel examples, in other words? And how may the attribution of responsibility look similar or different in these two contexts?
So I should preface my answer by saying, hi, Mitch, I saw you there on the chat. And I can only respond by saying, I of course, am not deeply familiar with the Armenian genocide. I know what Hitler had to say about it, as everybody does. I would think that the same argument that I've offered in the lecture today also applies in that case. Absolutely. I would think that we could speak of Turkish responsibility in exactly the same way that we speak of American responsibility. Yes, I don't, pending deeper knowledge of what was going on or deeper study of what was going on in the Armenian case, I do not see any substantial difference, no.
Okay. Professor Whitman, was the argument of American responsibility used at the Nuremberg trials?
No. In short, no. Americans seem to show very, very little awareness of this. And to my knowledge, I mean, there's of course an enormous record of this. The American case, it was not mentioned by the Nazi defendants, I believe. It's a good question I should be better prepared for, but it certainly was not relied on by the Nazi defendants, which is pretty interesting. Their defenses sounded in a different key, which I could also talk about, but maybe I won't know.
If America was isolationist after World War I, how can the country be said to be globally influential?
Well, isolationism involved a resistance in the United States to direct intervention and participation in other countries and participation in international institutions. As I tried to say very carefully, American influence, especially in the 1920s, was first and foremost cultural influence. The influence of Hollywood, but of course also the influence of American industrial practices and the like. Americans, as far as isolationism did not imply in the mind of any American, as far as I know at that time, that others should not be entranced by, inspired by the American way of life. It implied only that Americans should not invest funds or blood in affairs outside American borders.
Okay. Your idea of geopolitical responsibility is based on a moral judgment that assumes that, quote, responsibility is being acknowledged. The Third Reich lasted 12 years. The US regime of white supremacy continues.
I think we should acknowledge it. I'm pleading with us to acknowledge it. And I will say there, I may have said it in passing here, the comparison of what's gone on in the United States with what has gone on in Germany is striking and distressing, in part because Germans have made such a sustained effort to come to terms with the crimes of their past. We have not done that in the same way in the United States. So yes, I think we ought to acknowledge it. That's exactly what I'm hoping we may do.
During the Great Depression, the reputation of American capitalism suffered a huge hit. Is America still the shining city on the hill for the Nazi?
So the Nazis were very, very interested. The Great Depression, of course, hit Germany as well. The Nazis were very interested in New Deal programs. I talk about this to some extent in my book, and others have talked about it elsewhere. The Nazis were very, very interested in New Deal programs as efforts to deal with the challenges of the Great Depression. It's a very, very delicate, so their interest in New Deal programs petered out, or in fact was directly repudiated after 1937 in effect. But in the early 1930s, the Nazis thought, as others did, that the United States, this is true throughout Europe, that in this general global crisis, the United States, although of course its economy was not doing well, nevertheless might be offering a model, and in particular that Franklin Roosevelt might be offering a model for coping with the tremendous difficulties of the Great Depression.
Okay, next question. Can we critique the Germans for, quote, not knowing what happened in the concentration camps and extermination camps when we Americans have absolutely no idea what is going on inside CIA or NSA headquarters?
Well, I mean, I have no idea what's going on in CIA or NSA headquarters, and I don't know that I say honestly, I can't imagine that it's whatever the evils may be of what goes on in those institutions. I can't imagine they're comparable to what went on in the Nazi extermination camps, honestly. But in any case, to the extent there's a proper comparison, I would come back to what I said in my cri de coeur at the end of the paper. Of course, that's the question is, of course, the question we must address. Who are we to sit in judgment is exactly the question we have to ask here. Yes, indeed, that's the question that we must ask. I would focus much, much more on the things that I mentioned in the talk than on the CIA or the NSA. But yeah, that's the hard question. That's exactly the hard question, of course.
Next question. I'd like to know more about Nazi commentary or arguments regarding the destruction of Native Americans and its relevance to the genocide of Jewry.
So as early as 1928, Hitler, in a speech, praised the Americans for having gunned down the Redskins, that's his language, gunned down the Redskins by the millions, leaving only a small remnant to be penned up in concentration camps. In 1928, that is to say, Hitler was already pointing to the American example. And in the 40s, during the course of the Holocaust, he and his table talk, and Hans Frank I mentioned in particular, but other Nazis as well, cited distressingly the American example then too. So they were aware of it, they talked about it. Once again, it would be impossible to prove that they wouldn't have done what they did unless there had been an American example to cite. That would be the sort of causal argument that I've tried to rule out from the beginning, but they did talk about the American example.
Can you think of examples of the opposite scenario where a country modeled a positive example, where a country modeled a positive example that was as influential as these very horrible examples?
I mean, the country in some ways is the United States. As I said, there's more than one America. The United States, to an important degree, has also been a model for the establishment of liberal, humane, democratic government in the world. To an important degree, Americans exaggerate the extent to which our example has mattered, but it's mattered. And it especially mattered after 1945. So, there isn't one single sinister United States. There's been a lot that's gone on in the US, and American global leadership has certainly been exercised in ways that I admire. And the same can be said of other countries. So the French Revolution inspired a lot of good stuff outside France. So, again, yes, of course, global leadership can be exercised and has been exercised in ways that ought to meet with our approval.
Professor Whitman, what do you mean exactly by, quote, American responsibility? Germany was not tried as a whole. In fact, the idea of collective responsibilities was dismissed at Nuremberg. And just to follow up, are there certain Americans who bear responsibility? Do you mean to blame America as a whole?
So, I mean, this is another tough philosophical question that I didn't want to dig into in the talk. As I said, the Kantian philosophy, not just Kantian philosophy of history, but Kantian philosophy more broadly, requires us to think in terms of individual and not collective responsibility. That's absolutely right. And that is the reigning philosophy among most moral philosophers today, most commentators on these kinds of problems. I will say that I think that that view is problematic. I don't think we should only be talking in terms of individual responsibility. I think there are concepts of collective responsibility that are important, valuable and necessary. But as I began my response by saying, going into detail would involve going into more complex philosophical arguments that may turn out to be unpersuasive than I think this is the moment to enter into.
And just to, again, follow up, are there specific individual Americans you would identify as complicit?
I don't think so, not particularly. No, I really don't. I don't think, in the events that I'm talking about in the early 1930s, the Nazis didn't draw on direct advice or encouragement from any Americans. They drew on their knowledge of American law. So no, I would say not.
Are you familiar with the work of Stefan Kuhl, his book, The Nazi Connection?
Yes, of course, and I mentioned it briefly. I'm sorry, yes.
Oh, okay.
I'm sorry, I interrupted you.
No, how does it relate to your work?
So he demonstrated convincingly something that I mentioned, which is the tremendous Nazi interest in American eugenics. Mm-hmm. And the Nazis did have a tremendous interest in American eugenics. It's worth emphasizing that their interest in American eugenics resembled their interest in the other aspects of race law that I've talked about. Their interest in American eugenics had to do with the fact that Americans were extremely innovative legislators on matters of eugenics. They came up with all kinds of creative legislation. Belief in eugenics was very, very widespread in the world. The US was, alongside Sweden to some extent, one of the very, very few and by far the most important example of a country that had really written eugenic policies into the law. And that's what interested the Nazis. That's what interested the Nazis. And the same is true of the kind of race law that I'm talking about. The great difference in the race law that I'm talking about, once again, to reiterate what I said before, is that it involves not population planning or racial engineering. It involves degradation. It involves the creation of forms of second-class citizenship. It involves humiliation. It involves the range of practices that we associate with Jim Crow that have nothing to do with eugenics as such. But it is undoubtedly the case that the eugenics story is a big part of what went on.
Okay, there are a couple of questions, at least, that have to do with specific examples, the way in which Nazi Germany drew from the United States and the Jim Crow South. The different questions are worded differently, but could you speak more about this, about how some of the actions that occurred in the United States connected to Jim Crow laws or to the laws themselves, how exactly were these appropriated and deployed by the Nazi regime?
So it's a long story, which I go into in the book, and I don't think I can give a full answer here. The Nazis were interested in a variety of aspects of Jim Crow. I do want to emphasize, by the way, that the Nazis weren't only interested in Jim Crow. They were interested in all race-based legislation in the United States, and many races, what they thought of as races that were targeted by American law, were not the targets of Jim Crow as such, which targeted only African Americans. Among Jim Crow practices, there was a lot of Nazi interest in segregation. The radical Nazis pointed to segregation very early on. We can reconstruct a difference of opinion among Nazis about what use to make of segregation. As I say, even the radical Nazis thought that segregation went too far. They thought that, in particular, it should only apply in public and not in private. I could say more about that if somebody were interested. There were relatively moderate Nazis. I know it sounds bizarre to talk about radical and moderate Nazis, but there were such things. There were relatively moderate Nazis who did not want to introduce radical style criminal race legislation in Nazi Germany, but just wanted to introduce American things resembling American segregation as a way of, as I said, educating and enlightening the population about the dangers of race mixing. They lost out. The Nazis were especially interested in American anti-miscegenation legislation, that is, law barring marriage and sex between members of different races. And they studied anti-miscegenation law with special care. My book in particular focuses on their interest in anti-miscegenation law. In other respects, they were interested in American immigration law, in American efforts to disenfranchise African Americans, and other aspects of American efforts to create a new form of second-class citizenship. The Nazis, of course, also wanted to create a form of second-class citizenship for German Jews. And they studied the American example in that respect.
Moving to the current moment, the question is, are you saying, according to your premise, that Donald Trump encouraged and was complicit in the insurrection, but could not be criminally charged?
On the contrary, I was saying that so of course this is not a question that has been adjudicated, and one can only, as a lawyer, one must be careful in drawing one's conclusions. But I think he certainly could be charged under the law of complicity. Certainly could be charged under the law of complicity. The word incitement is often used. That's because it's the word that appears in a First Amendment case, the Brandenburg case. But the logic of the law of incitement is the logic of the law of complicity. We use other terms like solicitation. I personally have absolutely no hesitation in saying that he could be charged as complicit in what happened in the sack of the Capitol. But of course, I haven't gone into the details here in the lecture, but that strikes me as actually quite an easy one. If I put it on the exam, I don't think the students should have a hard time with it.
Professor Whitman, a number of questions keep returning to the role of individuals, either Americans or Nazis, in the story you're telling. So some questioners have asked about people like Henry Ford. Others are asking about individual Nazis like Rosenberg. Can you give examples of individuals and how they figure into your argument?
So I mean, the logic that I've offered would also apply to Henry Ford, sure. As an individual, I mean, he even counted as a global leader admired all over the world, and as a terrible propagator of anti-Semitic screeds. It's terrible. So yes, I mean, all of the logic that I've run through in the paper would also apply to Henry Ford, to my mind, unproblematically. Mm-hmm. To my mind, unproblematically. I spoke of geopolitical leadership because, of course, I'm trying to speak not of individuals, but of a collectivity, of a polity, of a nation. Although, as an earlier questioner rightly observed, I haven't defended the proposition that there could be something like collective responsibility. That's true. That's a reasonable objection. As for Rosenberg, sure. I mean, but Rosenberg's collaboration in what happened was much more direct. That presents many, many fewer problems as a matter of criminal law from my point of view. Many, many, many fewer problems. There are additional difficulties in assessing the criminal liability of individual Nazis that I think I'd better not go into. But I'll just say briefly, the defendants at the Nuremberg trials offered a defense which was not without some substance in criminal law. The defense was that some, not all, some of what they had done was not criminal at the time that they did it, and therefore they were being prosecuted retroactively. That's not a frivolous argument. That's not a frivolous argument. And in the case of, and I have more to say about that. I mean, my view based on that is not that they should have been excused, but that in the last analysis, criminal law is not really the right way to deal with them. But that would require a different lecture. But so individual Nazis could raise that sort of objection to criminal prosecution, and it would have to be taken seriously.
Maybe just one or two more questions. And there are two questions about specific books. Someone asked for your comments on Zygmunt Bauman's book on the Holocaust and modernity. I believe that came out in the late 1980s. Uh-huh. So that is one question. How does your argument about eugenics relate to Bauman's argument? And the second question about a book is the more recent book, Caste. And the question is Caste accurate in its depiction of Nazis looking to the United States as their model legal underpinning for racial discrimination?
So with regard to the first, I'm not going to answer the question because I really have, in my book at least, make no claims about the Holocaust at all. In the book, I try to focus very, very narrowly on what happened in the early 1930s. In the run-up to the Nuremberg laws, because it's in the run-up to the Nuremberg laws that we see the Nazis directly studying, citing, copying American law. That's not true of the Holocaust. And so my argument about influence doesn't apply in the case of the Holocaust. I cited other scholars, and because it's important to my argument here in this lecture, maybe I'm responsible for that reason, who talk about the model of American westward expansion. But really, I have never tried to explain the Holocaust, and I would avoid trying to explain the Holocaust. I will also say that the burden of my claims doesn't involve eugenics as such. I'm trying to supplement our understanding of eugenics. And to that extent, again, I would avoid the question, although I suppose, let me back up a little bit. I am talking about a form of modernity to the extent that I'm talking about very advanced, innovative American legislative and legal techniques. And maybe you could spin an argument that started from that point of view, that would, from that point of departure, that would be interesting. It could be, but I can't really do better than that in answering. With regard to the second question, what Isabel Wilkerson says is drawn directly from my book. She summarizes what's in my book pretty accurately. She gets a little of it wrong. Every author, of course, resists being quoted at length, and I do too. But she's just citing my book, and she's basically right in what she says in the book.
Okay, and you're referring to the book Cast. So this is the final question. Anti-Semitism predates Nazism by decades and centuries. You could easily implicate institutions, including established churches, in religion. Is that the case?
I think that's a question for you, Tony, more than it's a question for me. I have an interest, but I'm not really a historian of anti-Semitism or, anti-Judaism, as sometimes people will say. I have a tremendous interest in the subject, but I don't think I'm enough of an expert to give a good answer to that one.
So with that, then we'll bring this to a close. Again, Professor Whitman, thank you for your erudite and careful and thought-provoking argument today. I appreciate it, and I appreciate everyone in the audience for attending and for posing these very, very thoughtful questions. So again, thank you very much.
And my thanks to all of you. Thank you so much for spending the time.
Okay, take good care.
You too. Bye-bye.
Bye-bye.